Hey everyone, Natalie here. In this video, we're going to be looking at types of interinstitutional agreements in relation to IRBs. So let's get started. To give a quick overview, we're going to be looking specifically at defining different types of agreements, elements of interinstitutional agreement, and obligations of institutions or organizations. So the first step is types of agreements. The agreements reached may be presumed or formal documents developed by lawyers or something between. If only FDA is involved, agreements are rare and, if used, are primarily about scope of work. No agreement is required by regulation unless an FWA is involved. So what's presumptive or assertive opt-in? Well, perhaps the most common among independent IRB organizations is a presumption of agreement. Many sponsors and sites submit the IRB without any prior agreement except perhaps a non-disclosure agreement. The presumptions are that the IRB will operate in compliance with regulation, that the IRB organization will supervise it, that the site will be responsible for provision or resources necessary to conduct a study, and that the researcher will conduct the study according to ethical principles, applicable regulations, and the determinations of the IRB. Now, frequently the IRB application forms have a series of assertions or certifications at the end for the signature of the applicant. These may or may not be required for institutional acceptance. The second step is simple interinstitutional authorization agreements. The OHRP Institutional Review Board Authorization Agreement form is the simplest of all agreements. It indicates that there is some relationship between the two named institutions. Many independent IRB organizations have their own version of this form for clients with FWA. Their form generally builds on the OHRP form, but often in terms of understandable nature to people less familiar with OHRP language. Next is the Interinstitutional Memoranda or Agreement. The CTTI introduced guidance in 2013 with several suggestions, part of which defined what should be in the contents of a more formal agreement. The guidance suggested defining the role of the reviewing central IRB and institution relying upon it, then lists a number of duties assigned to either both of these entities. Presumably, this is used in situations where the relationship will be ongoing and will involve more than one review. And last but not least is legal contracts. This is the last used type of documentation. Primarily, it's used for long-term agreements between larger entities. All right, so now that we have a little bit more of an idea on the types of agreements, let's move on to elements of interinstitutional models. So before I begin, elements of an interinstitutional agreement need to kind of be spelled out. Things like who is involved, including any component unions, what standards and rules must be used, the obligations of the institution providing the review, the obligations of the relying institution, and those obligations that can be shared or delegated to others. Agreements generally reflect two institutions, one in which the study is being performed and one with the reviewing IRB. Consortium IRBs may have multiple agreements or maybe signatures. Central IRBs providing review for a number of investigational sites may have a single agreement with a sponsor or may have certifications on the investigator application forms that are sufficient for their needs. Regardless of the structure or the number of parties, all signatures and people should be considered in the following elements. The first is parties and the elements. So the institution providing IRB review, in this case we can refer to it as Institution A, is the organization responsible for the operations of its IRB. This can be an independent IRB organization, a specialty IRB established by an institution for a set of studies, or a federal board. The institution's seating review authority and relying on the other IRB, which is, we can refer to it as Institution B, although one institution may be named, it should be clear for whom that institution is signing. So the question is, does it have the component unions that will be involved? Are there other subsidiary agreements that bring unnamed other institutions? Does the person signing for that institution have signing authority for the other involved components? Another thing to think about is scope and standards. So the agreement should be established in the realm of studies to be assigned to that institution, A. For example, it might be one study, all sponsored studies, or all multi-center studies. Regulatory and ethical standards should be very clear. Some studies may only require the Common Rule or FDA regulations, while others require application of internal conference of harmonization, Department of Defense, or maybe even Veteran Affairs regulations. Although the Belmont Report is the most cited ethical standard, both parties should know what the other is using. With that being said, let's move over to obligations of the organization. We'll first start off with obligations of the organization providing IRB review, and we can refer to this as Institution A, and then we'll move on to Institution B. So to start, Institution A. Regardless of where it is, the IRB must be registered and must comply with the regulations and the standards, generally FDA and the Common Rule. So a couple steps in order to do that is, number one, notify institution about any change of status. This may include change of ownership, warning letters, or maybe even accreditation. Number two, review studies, consent documents, and sites and investigators in compliance with regulations and guidance. Number three, a consent form, and provide a consent form and give it to the site unless the approved consent form is to be provided through a sponsor of or CRO. Number four, provide IRB communication of decisions to the investigators and others requesting notice. Number five, notify authorities, for example, FDA sponsor institution, as appropriate to the circumstances of complaints, serious or continuing noncompliance, unanticipated problems involving risk to the subject or others, and significant new information. And lastly, number seven is allow reasonable inspection of authorities as relevant to the situation. For example, OHRP if under an FWA or FDA regulation. Okay, now we'll focus on obligations of the institution relying on the organization's IRB, and we're calling this Institution B. Okay, so to accept the review of an external IRB, an institutional HRPP must have a policy that allows external review. External IRBs can approve investigators and their research site, but it is up to the performance site's policy to determine if the approval is acceptable. Every institution, regardless of size, also has an obligation that cannot be outsourced. Institutions must provide a safe environment and sufficient resources to achieve compliance and safety. They must also maintain a policy that all staff can understand their obligations. Here's a couple examples of an institution's obligations. Provide a single point of contact to assure communication is facilitated. Inform the reviewing IRB of any special institution or community considerations. Maintain internal policies for conduct of human research. Oversee investigator compliance, maintain FWA if institution is engaged in federally funded research, assure compliance in the conduct of the study, including compliance with state law, IRB decisions, or HIPAA, notify the reviewing IRB and other authorities, for example, FDA sponsor or OHRP, conduct conflict of interest review and notify the reviewing IRB if any conflicts are identified, maintain insurance, keep records as agreed upon, assure compliance with state law, and comply with HIPAA if it is a covered entity. Okay, with that being said, let's move on to obligations shared by both. So some obligations are evidently shared by both Institution A and Institution B. These might be or include the following. Number one is an agreement on definitions of critical terms such as anticipated problems. Number two is reporting obligations. Both institutions have equivalent reporting obligations to each other and to the authorities. And number three is resources. Both institutions must have resources sufficient to carry out their duties for protection of subjects. Okay, and the last step is obligations that can be delegated. Most of the obligations that can be delegated are not IRB functions, but do impact the way the function is carried out. So this could include the following. Number one, training. The extent of training is often determined by IRB policy, but if the institution HRPP has a higher standard, it can certainly impose that on investigators. Number 2 is HIPAA waiver of authorization. An IRB or HIPPA privacy board can grant a waiver of HIPAA authorization. And number 3, assessment of conflict of interest and appropriate mitigation. This is most often taken care of by the institution, not the external IRB, as it affects operations and non-IRB areas. Okay, that's it. For more information on IRBs, please continue on to the next section in Module 2.